To this now, Afriforum has filed an urgent court bid to prevent municipalities from implementing Nersa's approved electricity tariff hikes. The lobby group claims that councils failed to conduct what is called the cost of supply studies. Let's speak about this now with Afriforum's head of local government, Morne Mostert. Morne, good evening to you, and thank you very much for your time. Let's begin with what you say is municipalities failing to comply with the prerequisite assessments for price increases. Put that in plain language for us. What were these municipalities supposed to do?
Good evening and thank you. Yeah, just take a step back to 2022, where there was already a court ruling that forced Nersa the new methodology to force them to have municipalities supply them with cost of supply studies. So cost of supply study in the most basic term is a study to show what does it physically cost a municipality with regards to the infrastructure, with regards to maintenance and personnel. What does it cost them to distribute electricity to consumers? And what is the percentage, or what is the point of, let's say, profit or that they are making from selling electricity for it to be put together in one single tariff to be paid by different types of consumers? Now, this document puts, let's say, scientific support to when you're required to pay this electricity tariff. We have seen that Nersa has not had this scientific approach for more than a decade, which basically had the effect of increasing the electricity tariffs fourfold in the last decade. So it's not a mechanism that protects the consumer. And now that there's already this piece of legislation that have already required it a decade back, and now Afriforum is taking the stance to say, if a municipality does not have a cost of supply, they cannot apply for a tariff increase. And we have seen that Nersa has had the same idea last year, where they warned municipalities to get their houses in order for them to could apply for a tariff increase. Yeah. Sadly, we have seen, or Afriforum did not get the number of municipalities that handed in, but about 7 months back, Nersa's own story was that there was only 2 municipalities that handed these documents in. So Afriforum's court case is forward-looking to say, let's get these cost of supply studies in, let's get businesses and civil society in to address and check if those tariffs are rationally related to the selling of electricity. Yeah. And that's why this case is for us very important.
So I think, based on your explanation, if I were to just put it in much shorter language, you're saying that these municipalities, their failure to conduct this cost of supply studies, these studies are in essence meant to inform the electricity tariff increase. Now, question is, if there was a failure to conduct these, how or what determinant would municipalities use in order to come to a tariff increase determination? Am I confusing this altogether?
No, you're 100% correct, and that's in essence what Nersa's problem is. You know, they have for the last decade basically played this game where you only put percentile on each of the previous tariff, but there's no detail or explanation of why the original tariff was set in that way. So what Nersa has done, because they see that the municipalities aren't bringing these cost of supply studies in, and just for reference, at the end of last year, Nersa tried to simplify, make a simpler document for municipalities to have a simple version of the cost of supply studies. But to date, they have not received even the simplified version of it. So the only the request of Nersa for municipalities is to send some financial figures for them to be able to give this tariff increase, which not only we think is improper, the court in 2022 already stated that it is improper and unconstitutional, and Nersa undoubtedly just used the same mechanism as it did then and tried to apply it to municipalities.
Yeah.
Once again, it's important for us that if you have those details inside, it's possible to scrutinize the electricity tariff, but that is obviously what municipalities don't want. They don't want to civil society or businesses to be able to scrutinize their tariff that they're basically using to fund other services and not focus on the electricity reticulation.
Yeah. Morne, is it too simplistic to say that municipalities were possibly overcharging consumers here? And is it possible to even go further and say there's no telling how much profit would have been made if the conclusion is that municipalities did and have been overcharging consumers?
Yes, you're absolutely correct. Dating back to the court case of 2022, the court specifically said that municipal consumers are paying exorbitant fees to municipalities because there is no rationale linked to the manner in which the tariff you are paying. So it's a very real, it's almost to say fact that municipalities has pocketed millions of rands by implementing or by not implementing this cost of supply studies and just riding the wave of percentile increases each year. So it's a very real problem, and that's why this methodology needs to stop. That it has already been declared unlawful, but it needs to stop. And what we feel is that by getting this court order, if we are successful, it would really energize municipalities to do these types of cost of supply studies and hand it in within the next financial year. In the same sense, it might sound that like the municipalities aren't going to be able to cover the charges, but that is just factually incorrect if you look at the manner in which the court already dealt with this issue.
I now want to focus the attention on Nersa because, as you say, theirs in January of this year, you're saying in one of the articles I've read that they then sent a letter to municipalities saying, if you can send this information or these few steps, then we will consider your tariff increase.
That is correct.
Why is Nersa doing this?
Sorry.
Why is Nersa doing this?
So the simple way to explain why Nersa is doing this is although they have threatened municipalities, municipalities have not complied with these cost studies. So even if they threaten them now, it gets to the point where they need to use the legislation and the remedies at their disposal to force municipalities to adhere to not only the Electricity Regulations Act, but also the recommendations that they have made in last year, October. So they need to force them. And the one way in which they can force them is to say municipalities that don't have the legislative means to actually to apply for a tariff increase, to not let them have it. I want to add on that to say that the Electricity Regulation Act basically states that if only an efficient licensee, uses those phrases specifically, only an efficient licensee can make a profit from selling electricity. Now, an efficient licensee would be one that has these types of cost studies in place to hand over to Nersa. So we are sitting with a bunch of legal requirements where Nersa, as the regulator, should enforce their legislation, their enabling legislation, and actually tackle these municipalities whose houses aren't in order.
Can it be argued, as things stand, that Nersa has been enforcing, using the legislation, has been enforcing this or these measures on municipalities? Or is it a case of, well, we're here now, and as Nersa, we can't approve unless you give us this, but please, we're begging you to do this? That doesn't sound like enforcement. If anything, it's really being lenient.
It is really being lenient. It's lenient to such a matter that Afriforum sent them the letter in April this year, where they did not reply, answer, or give us any information with regards to the process that they are going to follow. So it seems like Nersa is unsure on how to approach this, and the only way that we see it is that they need to use the mechanisms at their disposal and not give municipalities that aren't complying a tariff increase. This reluctancy has been fought. Let me take a step back. The court order in 2022 gave Nersa an additional year to be able to apply the cost of supply methodology, and still they have failed to do so. So it is reluctancy in not applying them as the regulator, which is the primary function of the regulator. And it's very interesting or telling that the energy regulator of South Africa's primary focus should be to protect the consumers. And currently, they are not protecting the consumers. They are actually just protecting the municipalities.
And it is absolutely shocking if indeed your studies here are correct. So let's conclude then, Morne. The understanding is that the majority of municipalities in South Africa are in deep financial trouble. If I were to put a figure on it, it's estimated that 75% of them are in deep financial trouble. And if they don't get these electricity tariff increases, they will probably go deeper into the red. What is the ultimate goal of your court case? Is it to exercise exactly this, that they must be punished for not doing what they ought to have done, so that next time around they do what is required of them, and that will then be in compliance with the law?
It's not such a process of punishment. It's rather a way to energize municipalities to comply. It has already been stated that municipalities are possibly to extreme amounts overcharging municipal consumers. So it's not like municipalities are losing funds that they ought to be required by a legal process. And once again, the importance of of our application is those that do comply are available to do the prerequisite tariff increases. So there should be a large focus on transparency. There should be a large focus on accountability. And how is municipalities being held accountable if the regulator just time and time again postpones this obvious and necessity of a legal requirement for municipalities to comply with? And that is what Afriforum's basic message is. Let's see if we can get municipalities to a place where they can charge consumers a rational amount for serving electricity, and to ensure that they become efficient licensees, which in general will help the whole of the electricity industry, or the electricity industry as a whole. So that is the aim, that is what we want to do, and that is the reason why we brought this urgent application.
Morne Mostert is Afriforum's head of local government. Let's take a break. When we return, the South African Local Government Association's head of energy, Nhlanhla Ngidi, has been listening to this conversation. He will respond. Let's continue our conversation with Afriforum, and they are launching an urgent court bid to prevent municipalities from implementing Nersa's approved electricity tariff hikes. Joining us now to respond to what Afriforum has been saying is the South African Local Government Association, the head of energy within that institution. His name is Nhlanhla Ngidi. Mr. Ngidi, good evening to you, and thank you very much for your time. Can we start with whether or not municipalities have indeed failed to comply with this cost of supply studies in order for them to get these electricity tariff increases?
I greet you, Butloli, and your viewers at home, and thank you very much for having me. I think I want to clarify quite, a lot of things that have been discussed in the earlier interview. I wouldn't say that municipalities have failed. Municipalities have not failed. When the regulatory methodology that was used by Nersa to regulate municipalities was rendered unlawful by the courts in 2022, since then we started working in the background. There's been a lot of work that's been happening in the background, but I think maybe Afriforum has not been reaching out to us to understand what kind of work and the amount of work that we're doing in the background to try and assist the municipalities to ensure that within the 12 months that was declared by the court for municipalities to have done cost of supply studies, at least we would have moved somewhere. Yeah. And I want to also correct what Morne has said about the cost of supply, simple costing tool. That simple costing tool comes from Salga as well, which is a tool that we were trying to actually develop as an alternative to the cost of supply studies, because cost of supply studies take quite long, between 18 months and 24 months, and it's an exercise that costs anything between 2 million and 3 million rands, and we know municipalities are cash strapped. So as Salga, we've been doing a lot of work in the background. We have been training municipalities on this costing tool, and we have been trying to source some funding also to do the actual cost of supply studies for the municipalities. So at this point in time, I think maybe Morne didn't have the information. Nersa has issued a notice. There is about 68 municipalities that have submitted, cost of supply studies with their applications for the tariff increases. Yes, we have about 167 municipalities licensed to, to sell electricity. And, the reason why we have this 68 is obviously because of the efforts that we've been making in the background, which I think we needed to communicate more with the stakeholders. We do support, that we need to have the tariffs that are very close to being cost reflective. For the past, 20 to 30 years in the country, we've been, charged tariffs that are not really reflecting how much it costs to service a customer, on the electricity services. So yeah, I think this is historical, and we are trying to address it. Nersa is trying to address it with a new methodology, but we are all catching up with time. So okay. I think we need to work together because, yeah.
All right. I just want to come in quickly because this can be very technical for the viewer. So I do hear something that appears to be an admission on your part that before these cost of studies were conducted, municipalities were indeed charging consumers. But can you confirm for us whether overcharging was the order of the day here?
Thank you for the question. I'm smiling because, when we talk about cost of supply studies and cost reflective tariffs, people seem to think that the prices will actually go lower. We might be shocked and find out that what we've been charging the customer is way below what we're supposed to be charging the customer. I'll make you an example, Butloli. Right now, with the methodology that has been rendered unlawful, for the formula that had been used for municipality, it had allocated about 70 to 80% of the municipal cost drivers on the bulk supply from Eskom. So municipalities are left with 20%, and that 20% is basically for human resources, the salaries, and maybe O&M also for the network and the infrastructure of the municipality. And then obviously the markup that always applies over and above that is always regulated by Nersa through its own, prudency studies that they do based on this formula that they use. So I don't believe that customers have been overcharged. I can share it with you now. Some of the cost of supply studies that have been done has actually shown tripling of the price. So I think we are making a lot of assumptions here, but all of us are very, very supportive that the industry must move towards charging people cost reflective tariffs, because we are moving towards an industry that is transitioning into a market. We're going to have an energy market soon in the country, and we can't have an energy market that doesn't operate on, the cost reflective prices. So
Mr.
we
Ngidi,
do support that, and I think yes, sir.
I'm sorry to interrupt you, sir. The court order of 2022 said that municipal licensees are overcharging municipal consumers already. So are you saying that that court order was wrong?
I think, the answer to that question is, if the court said we were overcharging the customer, what was it based on? Because there were no cost of supply studies that were done then, and we didn't know. I think even ESCOM today doesn't know what it actually costs to service a customer based on cost of supply studies. So yes, I think there was a sample and the benchmark that was done by the stakeholders, the private sector, and they came into conclusions that they've been overcharged. And yes, also, the tariff architecture right now is in such a way, because we are a developmental state, it's in such a way that there is a lot of cross-subsidization within the blocks of the tariffs. And it so happens that the commercial and the industrial customer feels the pinch, because there's the cross-subsidization that takes place, because you have those lower customers that should be subsidized, because obviously we are a developmental state. We are not yet there where everyone is able to actually afford these soaring prices of electricity.
All right. Final question to you, sir, and it's going to be 2 in 1 because of time constraints. So you have said that 68 municipalities have now submitted the cost of supply studies. Out of 257 municipalities in South Africa, that means 189, if my calculations are correct, 189 are still missing these cost of supply studies. How is that going to be remedied? But second of all, if Afriforum succeeds in court to block these tariff increases that are supposed to come into effect next month, what will the financial situation of these municipalities be?
Thank you. I think just to be quick, to correct a bit of detail in terms of the numbers, it's 167 municipalities that are licensed to distribute electricity. So which means we have about 99 municipalities that hasn't submitted, and there is work happening in the background. There's been a lot of training and capacity building for municipalities to be able to even use the simple costing tool, because we are moving from an old dispensation to a new dispensation. So the municipalities also need a bit of capacitation to be able to get to the point where they are able to cost things correctly. They have to also quantify their assets and infrastructure correctly in order to come out with a correct price. So what do we need to do? First, maybe let me answer a question about what if the order goes for, in favor of Afriforum? I think that would be unfortunate, because you know what will happen? It would mean that municipalities must charge customers based on the previous financial year tariffs. And I think you can already see where this is going. If municipalities are going to continue charging on the previous year's tariff to the customers, but the ESCOM tariff that they are charged on has increased and it's not being challenged by the Afriforum, that means that municipalities are immediately going to be going under. So that is the problem. That is the problem that this court order might actually bring. And, my solution, or my thinking, or Salga's thinking around this is a solution of working together, because we are not, against the view of cost of supply studies and cost-reflective tariffs, but I think we need to work more together as the industry to actually fast-track this. And I'm calling upon Afriforum itself to talk to us, to understand what is going on and what we are doing. Because I think what I'm hearing from the interview earlier is that municipalities are just delinquents. They are not actually doing what they need to be doing, but that's not the case.
Yeah.
We have been busy since October 2022, training municipalities on this simple costing tool. We are the ones at Salga who submitted this simple costing tool to Nersa and asked Nersa to actually approve it as an interim measure. And we're working on that, and that's why we have a number of 68. And it might look like 68 is not a big number. It's actually big because of the magnitude of work that needs to go in within this cost-reflective tariff regime. Thank you.
Nhlanhla Ngidi, thank you very much for your time.